On the back of that M&M's video, some people in the comments raised some really interesting questions about contracts generally. So I thought take the opportunity to talk about one particular aspect because it's something that will have like everyday applicability. It's a useful thing to know because there's one area of law we all encounter every day is entering contracts. You know, every time we go into a shop. So what do I want to talk about? Well, it's this. We talk about terms and conditions, don't we? However, whilst all conditions are terms, not all terms are conditions. What do I mean by that? Well, the terms are the obligations on each party in the contract. You know, if you offer to sell me your car for a particular price and I accept that offer, then I'm obliged to give you the money and you're obliged to give me the car. And if either of us don't do that, we can sue each other. But those terms, they're split into what we call conditions and warranties. What's the difference? A condition is something that is absolutely fundamental to the contract. If that fails, then what was the point of the contract? A warranty is something that, again, it's another promise, it's another obligation. However, if there was to be a breach, the effect doesn't necessarily, spoil the purpose of the contract. Say, for instance, I want to hire somebody to carry out some work. And I want, particular level of experience. So I say, okay, I'm going to hire you to do this work on, X pounds per hour. And I want you to have had at least 5 years experience. And you come along and you work and you do that. Turns out you've only got 3 years experience. Well, you're actually in breach of contract, aren't you? But you've done the job, so how fundamental is that? And that's why that's a warranty. So what's the major difference between conditions and warranties? Well, if you breach a condition, the other party is entitled to terminate the contract. They don't have to, but they can choose to do so, and they can also sue for damages. If you breach a warranty, the wronged party, all they can do is sue for damages, if they can show loss. And again, to give you some examples here, imagine I am an opera singer, and you book me and say, right, I need you for a 3-month season, and grand opening night is September the 1st, and I'm ill, and I can't do opening night, so you have to get somebody else in there. Am I in breach of contract? Yes, because you booked me to perform, and I didn't. Is that a condition or a warranty? Because the performance did go ahead, albeit not with me. Well, actually, no. The courts have said, and the reason I said opera singer is because there's a couple of cases on this. The court said, well, no, that's something fundamental. Opening night is the grand gala night. That's what people come to see. That's what everybody writes the reviews about. So yeah, you not turning up for that actually made the contract pointless. Let's say, though, you book me and say, okay, grand opening night's the 1st of September, and I want you to do at least 6 nights of rehearsal beforehand. I'm actually ill again. I missed the first 2 nights of rehearsal. I do the other 4, and I do opening night, and all goes well. Well, again, I'm in breach of contract, aren't I? Because you booked me for 6 rehearsals and I only did 4. But can you say, no, you're not going on, I'm rescinding the contract? It turns out the court say, no, that was effectively just a warranty. So if you can prove a loss, you can sue me for damages, but you can't actually cancel the contract. How do we distinguish between the two? It's actually the effect. Now, courts, when they interpret this, you can actually set out in a contract and say these are conditions and these are warranties. That's not necessarily definitive, though. The courts put a lot of stock into that because they say, this is what you chose to agree and this is what you thought was important, and I'm not going to second guess you. But courts can sometimes say, well, actually, no, just because it's labelled one way or the other. As a matter of fact, I find something slightly different. If you don't label them, the courts can just sort of, apply their own logic and say, well, what's the actual effect of this? And you can get things that actually are arguably a condition in some set of circumstances and a warranty in another set of circumstances, depending on how bad the consequences were. But the courts will apply what they call the intention of the parties. And it's one of these strange things because it can be the last thing that either side wanted. But the court said, well, I don't care what either of you actually thought you were doing. This is what you actually have agreed to do. But there you go. So yeah, like I say, you might find that useful. And also you'll notice that now, and if you read, the small print on anything, just have a look and just see what is described as a term and a condition and what is described as a warranty. Right. Well, if you found that useful and there's no warranty there as to whether you would or not, please consider clicking the like button and also possibly subscribing. And I've also found out that you can share these things. So if you want to do that as well, that'd be great.